Welcome to the Legal Dart channel. Before we delve into some interesting stuff, let's learn one Latin phrase. De minimis non curat lex. This means, the law does not deal with trifling matters. We shall be dealing with brief facts of the Gabcikovo-Nagymaros case between Hungary and Slovakia under international law, and illustrate at least one application therein. On September 16, 1977, Hungary and Slovakia signed a treaty for the construction and operation of the Gabcikovo-Nagymaros system. The main aim of the project was for the production of hydroelectricity, the improvement of navigation on relevant portions of the Danube River, and protection of the areas along the banks from flooding. Two series of locks were to be built, one at Gabcikovo, within the province of Czechoslovakia, and the other at Nagymaros, in Hungary. The project was to be single and indivisible. Due to some criticisms, Hungary discontinued its part of the project and unilaterally terminated the treaty. However, Czechoslovakia unilaterally continued with the damming of the project. That was prior to the determination of Slovakia as a single state. Issues came up concerning the acts of both states. They thus reached a compromise and requested the ICJ to provide a resolution by deciding two vital issues. The first was, whether or not Hungary was entitled to suspend and abandon the project. Hungary argued that it was due to some environmental perils which could arise from the continuance of the project that caused them to breach their responsibility under the treaty. It thus sought to rely on necessity as the circumstance precluding its wrongful act. Nonetheless, the ICJ held that Hungary knew of the imminent environmental perils before signing the treaty in 1977. So since it had contributed to that very state of necessity it sought to rely on, it could not succeed. This is supported by Article 25 of the Draft Articles on State Responsibility. The other issue was, whether Czechoslovakia was entitled to proceed with the project unilaterally. The court observed that the treaty was aimed at a joint investment to establish a single and indivisible project. As such, Czechoslovakia had committed an internationally wrongful act by carrying it out alone on the basis of variant C, which was a term in the treaty. It ought to be noted that they were entitled to proceed to a provisional solution in 1991, but not entitled to put into operation the barrage system. Slovakia argued that Hungary's suspension and abandonment of the project had made it impossible for it to carry out its part of the work, which falls in line with the principle of force majeure, and that entitled them to proceed with variant C. It maintained that this was the only possibility available for carrying out the treaty in good faith. It also relied on the principle of approximate application, but the court observed that, even in relying on that principle, it ought to be exercised within the confines of the treaty. This was however not the case, making preclusion of its wrongful act incapable of sufficing. The court further noted that the diversion of the Danube River carried out by Slovakia with respect to variant C was not a lawful countermeasure because it was not proportionate to Hungary's defaulting act. Thus, this case falls squarely under circumstances precluding wrongfulness in international law. Hope this video has been helpful. Please be sure to leave a comment, like, and subscribe for more.